The hour of 7 o'clock having arrived, we're going to call the council to order. Let the roll reflect that all council members are present and a quorum has been established. This evening, ladies and gentlemen, we have a few presentations for the City Council. First, we have a Creative Minnesota Economic Impact of Art report update, and I'm going to recognize Dick Graham from HPAC to introduce our speaker. Dick, welcome to the meeting. Glad to have you here.
Thank you, Mr. Mayor and members of council. It's nice to be here. We were here a few months ago, introduced Sheila Smith and introduced the study of the impact of the arts on our community. I think you all have a copy of this at your desk. And you notice on the back that this study was sponsored by Creative Minnesota, Minnesota Citizens for the Arts.
We haven't got a copy of that, but if you
here.
make sure the council gets some, we'll appreciate it. We'll take it.
All right.
Thank you.
So Sheila, first of all, the study was initiated by HPAC, and we participated in the funding, bringing the study to Hastings. This is a much larger study involving almost all of the state. Sheila will fill you in on that. But we're the local sponsor, along with Minnesota, Creative Minnesota, and the Minnesota Arts Council. It's important and Sheila has called us and said there were some updates on this study, and that's why we're here tonight, to bring you up to date on this study. I just want to mention that when you look at these numbers, and we remind people of this all the time, that this study and this data was gathered, first of all, just from the nonprofit sector. It doesn't include the for-profit entities, and there's reasons for that because of where the data comes from, how the data is gathered. So it doesn't include Hastings Center for the Arts. It doesn't include the work that's going on out of Nan Bailey's winery, and it doesn't include the professional musicians, et cetera, et cetera. So these are pretty conservative numbers. Secondly, this data was gathered prior to the arts-based development. So not included in this is the $12 to $13 million in capital investment in this town, as well as I hear it's $65,000 to $70,000 annually in property tax that comes in from arts-based building. So when you look at these numbers, there's much more on top of that. Our board is very proud to have brought this to Hastings. We have some board members here that are here to again express their interest and support and appreciation for what you're doing with us. At this point, Sheila Smith has chaired this study. She will walk us through it till the changes, and we've also asked her to talk a little bit about communities that have done comprehensive plans for arts and culture, because that is really where we left off the last time we were here. We talked about communities that are doing comprehensive plans, and the question was, well, why doesn't Hastings do that? So she'll talk a little bit about what happens when communities do comprehensive plans. Sheila?
That's a bad day today. Yeah, I know, I'm tripping all over the place today.
Ms. Smith, welcome back to the council. Glad to have you here.
Thank you, Mayor, members. Thanks for giving us a little bit of time today. The reason we are here is that we decided to issue a revised report for Hastings. I did a post-project review of the research and discovered a typo had been entered in your calculations concerning artists and creative workers, so we wanted to correct the record as quickly as we could. In talking to Dick and his team, they decided to refocus their thinking on Dakota County only. The previous study looked at a couple counties, so this gives you the revised information. Note that the data that we got on nonprofit arts and culture organizations and their audiences have not changed. That's Hastings specific. The only numbers that have changed concern artists and creative workers. So and just a reminder, the Creative Minnesota Study is a statewide project of the art supporting organizations, everything from the McKnight Foundation, Jerome and Bush Foundations, Target Corporation, and statewide service organizations such as Minnesota Citizens for the Arts and Springboard for the Arts and others. Just talked about this. So the good news is the economic impact of artists and creative workers is actually higher than previously reported in this area. How do we get data on artists and creative workers? Dick thought it would be important for me to talk about where this comes from.
We collect federal data on employment in 41 creative occupations. That gives us the number of artists and creative workers in the area. In order to determine how much artists are spending in the county, we did a statewide survey of artists and creative workers and received over 2,000 responses. This was for the 2017 study. Through that study, we learned the average amount spent per artist on their artwork and their small arts businesses. And by multiplying one by the other, that gives us the economic impact of individual artists. So it's both federal data and direct surveys of the artists in Minnesota. So on a statewide basis, just as a reminder, we found 104,000 artists and creative workers doing 41 creative occupations. Here's a list of the creative occupations, everything from artists, graphic and interior designers, set and exhibition designers, dancers, choreographers, painters, theatrical workers, etc. And just FYI, by far the most common creative worker job is photographer. If you think about it, wedding photographers, advertising and print photographers, people who do photography for online websites and advertising. Second is musicians and singers. Third is writers and authors. And fourth is graphic designers. Those are the statewide numbers. So honing down just on Dakota County, we find 8,364 artists and creative workers. The number comes from the federal data. We learned from the survey that 3,229 of those would be full-time artists, 5,135 of those folks will be part-time artists. The economic impact of the spending of those artists in just Dakota County is over $57 million a year. Dakota County has one of the highest densities of creative workers in the state, with 38 creative workers per 1,000 workers. So of all the many thousands of kinds of jobs that people could have, we have a high level of creative workers in this county. So then honing down even further onto Hastings, just to reiterate the numbers that are not changing, we studied 16 local nonprofit arts and culture organizations. Here's a list of those organizations. ArtSpace was just entering into your city. This is before the building was built. So its budget was not included, but we're listing it because now there's such a player in your nonprofit arts and culture sector. And you can see the Hastings Prescott Area Arts Council, the Black Dirt Theater, Hastings Cable Community Access, amongst the larger organizations. Altogether, these 16 organizations serve nearly 50,000 attendees a year at nonprofit arts and culture events. In the metro region, from a different survey of attendees at nonprofit arts and culture events, we learned that the average person spends about $27.58 per person per event when attending a nonprofit arts and culture event. And that includes everything from going to a local business for dinner, to going to a bar afterwards, to buying souvenirs at the event, etc. What's great about the spending of audience members is that non-local members of the audiences are spending about 80% more than local attendees. So attracting attendees to your nonprofit arts and culture events from outside your community can bring dollars here that wouldn't have otherwise been here. So then a quick summary of the economic impact in Hastings of the nonprofit arts and culture sector. There was about $1 million in direct organizational spending and $1.3 million in audience spending, for an annual economic impact of $2.3 million at the minimum previous to ArtSpace joining the community. And this does not include the economic impact of artists and creative workers, which is the whole Dakota County, so you'd have to add a portion of that additional $57 million economic impact just for the artists that are in town. Unfortunately, the artist and creative worker data is only available by county, so I couldn't break it down further for you. Extrapolating from all of that $2.3 million spending, then there's about $257,000 in state and local government revenue generated from the nonprofit arts and culture in this area, plus an additional portion of $7.4 million in state and local government revenues generated by the spending of those artists. This is government revenue of all kinds, from not exclusively tax revenue, including tax revenue such as sales tax and property taxes, but also utilities fees, filing fees, etc. So that is a very brief, quick summary of the highlights of the Creative Minnesota study. All of our research is available for free at creativemn.org, so if you want to dig deeper, there's lots of comparables. Dick asked me to compare to a couple other communities that have done this study and what happened next. Two very good examples are Grand Rapids and Cook County. Both of them started out the exploration of doing a comprehensive plan for the arts by doing a Creative Minnesota study to quantify what was going on in the community. And then both of them took the next step of forming committees. In both places, those committees included city council members, the mayor, the EDA, the tourism authority, nonprofit arts and culture organizations, individual artists, and members of the chamber. And they sat down and talked through what their common issues were and how they could work together. I think what makes a successful comprehensive plan is communication. Is to get as many sectors of the community together at the table to talk about what the community needs and how everybody can help each other. And I think a couple of really great examples are in Grand Rapids, after the community gathered and worked on their comprehensive plan, the Chamber of Commerce and the arts community worked together to do a First Friday tour of downtown, where the nonprofit organizations opened, the artists opened their studios, and members of the public could go from studio to arts organization and then go out to eat and then go to the bars in downtown. And it's created a very lively art scene by everybody working together to promote it amongst all their various audiences. And you can see the additional activity downtown from that cooperation. The Chamber of Commerce in Grand Rapids passed a resolution with about 20 whereases talking about what great collaboration they've started now with the nonprofit arts community and the artists. The mayor told me that after he had seen the presentation of their study, that their city council talked all the time about how to promote the Civic Center because they knew that the Civic Center was bringing about $3 million into town. And then found out from the study that the nonprofit arts and culture organizations were bringing in $5 million annually, and they never talked about the arts. So he made a point then of having a portion of the city council meetings become how to promote their arts community outside of the community so they could draw in more audience members. In Cook County, similar process happened, but their common issue turned out to be low-income housing. That the nonprofit arts and culture organizations had a lot of instructors that would come into town. You know, they're really far away, people have to stay overnight. And there was nowhere to put them. They couldn't afford to buy housing in the city for the instructors. So they were putting people up in people's homes. The for-profits, all the resorts and such, they had trouble finding places to put all of their temporary workers that flood the Cook County in the summer to serve all the tourists. And the EDA had recognized the low-income housing as one of their priorities. So everybody was on the same page about low-income housing being, or temporary housing being the highest common issue that everyone had. Now they've done 6 or 7 projects. They've initiated all kinds of tiny home projects, low-income housing projects, and they're doing it all collaboratively because it's serving the whole community. So it's the kind of thing that you learn once everybody's sitting at the same table talking to each other and figuring out what does the community need. And that's something else that would come out of a comprehensive planning process, just through all that communication, figuring out how to bolster the nonprofit arts and culture organizations, how to bolster downtown, have everybody work together and moving in the same direction can help everybody.
Councilmember Vaughn.
Thank you, Your Honor. Sheila, thank you for the report. I have a quick comparison. You bring up economic development. I'm looking at the community development side. Dick Graham talked about our comp plan. It's a pretty big document when it has everything in it. Do you think it's a bigger impact to have that as a part of a comp plan? Or is it going to be more impactful if we had just a arts and cultural master plan that we can use as we work through projects and developments?
Well, I think the most important thing is that all the different pieces of the community are working together. As a practical matter, you need some portion of the government to have a stake in it so that there's continuity, that it's not expected that just volunteers will take care of everything. You need the decision makers like you guys at the table to all be talking together about what is needed and figuring out how to make it work. Having it in the comprehensive plan brings its level up in terms of importance. If it's separate, I think it's probably easier to ignore. I would want it all in one big plan, because that's also, as you're trying to figure out other pieces of the community's future, you want to be thinking about all these pieces together and how can they fit together, how can they help each other accomplish the goals that they're trying to accomplish. You might find more parallel movement if it's all in one place than if you have it separate.
Thank you.
Any other questions, council? Okay. Well, thank you, Sheila. We appreciate you being here tonight, giving us an update, and I know we'll continue to have discussions and talk about that comp plan.
Thank you.
Okay, thank you.
I just want to thank you very much for your time. I just want to add that the process that HPAC is at is we have started to the process of finding some professional help to organize, to do the plan for the planning, for a comprehensive plan. So that's where we're at, and you'll be hearing from us, and appreciate your support.
Okay, thank you.
Thank you.
Appreciate that.
Do you have any, want to add in, board members? Good, thank you.
Thank you. Next, we have a presentation tonight. The City of Hastings received a National Project of the Year Award on the Riverfront Renaissance. Who's going to present that? Okay, oh, Nick's here to present that. Nick, give us a report.
Thank you. I'll try to keep it brief, Mayor Hicks. Not a whole lot here. I just wanted to be able to share with you tonight the piece of hardware that I had the honor to pick up on behalf of the city down in Kansas City at the American Public Works Association Public Works Expo just a few weeks ago. It's a national recognition, as you mentioned, and in general, the Minnesota chapter did very well with their award submittals. I believe we took home 5 of the 25 various project awards. So a lot of good work in Minnesota, but Hastings obviously very special to all of us. It's kind of the cap on what I've seen as a series of projects that's been completely transformational to the downtown, created so much energy and excitement out of that, and it's really great to be recognized for the city that way. It's a reflection of all the work that went into it, from the committee that scoped out what we were going to do down there, the council for its support and leadership all along the way, the business owners and building owners in the downtown for letting us invade their turf for several years over to make it all happen physically, and the staff that worked on it, just top to bottom, we did this together. It's very special, and it's the 4th such award that we've received now for the program. So we'll find a special place here in City Hall to feature that with the other plaques and exhibits that we've accumulated along the way. But I just wanted to make sure to bring that by and show it off a little bit at the meeting. So that's all I had to say.
Well, I saw the pictures on Facebook, and it looked like quite a celebration. So, and congratulations to the council and to the staff and to the citizens who worked on that project from downtown and around the community. I think it's a wonderful testament to partnerships. When you have wonderful partnerships, you're able to get a lot of things done, and that's what we saw here. So thank you, Nick, for giving us a report on that.
You are welcome.
That award.
I'll leave that there.
Okay, council, we have before us the minutes of the regular city council meeting of September 4th, 2018. Any additions or corrections to the minutes of that meeting? Seeing none, they stand approved. We'll go to council items to be considered. Council, is there any additional items to be considered? Seeing none, we'll go to consent agenda. Council, what's your wish? Councilmember Fulch makes a motion to approve. No, Councilmember Fulch.
Thank you, Your Honor. I'd like to pull number 2, adopt a city purchasing policy, please.
Okay.
Thanks.
Okay, we'll put that item number 1 under administration. Okay. Is there a motion then? Councilmember Vaughn makes a motion to approve the consent agenda as amended. Is there a second to that motion? A second by Councilmember Bras. Any further discussion to that motion? Seeing none, all those in favor of that motion say aye. Aye. Those opposed, nay. The motion prevails. Next, we have under community development tonight a resolution consideration of the preliminary and final plat, Wallin 18th edition. John, why don't you give us the latest update? Thank you.
Thank you, Mr. Mayor, City Council members. I'll provide an update of the report itself. I know that the council members are well informed of the project at hand, and we had discussed this at the last meeting. So the project that we have, or the proposal we have before us tonight, is the preliminary and final plat approval of Wallin 18th Edition. Wallin 18th Edition is generally located east of General Stephen Drive, south of Greystone Road. It's about 9.5 acres altogether. This is the total area. The area that is up for development right now is around this cul-de-sac, which is termed Brandlewood Court. As you're aware, the original master development agreement for the Wallin development laid out 9 single-family home lots for the cul-de-sac. What's being proposed today are 14 villa homes. Those are single-family detached homes that would be proposed for the subdivision itself. We did meet about this on September 4th. We had some lively discussion related to concerns that have been expressed by the residents. Residents have expressed concerns during this meeting and in previous meetings related to the effect on the property values, having a change in the neighborhood that was not anticipated or was not expected upon purchase of their properties, and concerns about how this might lead to future effects or future changes of more villa homes within the neighborhood, as well as concerns about the properties themselves, standards that they were held to, and concerns that properties within this subdivision may not be held to similar standards. So that was a major point of discussion. There was a petition submitted at that last meeting. Council had similar questions and discussion as well. When we tabled that item at the last meeting on a 7-0 vote, what the council was looking for at the time was additional time to fully understand the effects of the development, how the effects might have on the neighborhood, home values, enforceability of covenants, those type of items. And so we left that, and over the last couple of weeks, we've come back with some further information, which I'll share with you tonight. One of those was a neighborhood meeting was held last Thursday, September 13th. The developer held this meeting. We had about 25 people, 30 people altogether that attended the meeting. It was a combination between a presentation by the developer, the owner of the development, Fieldstone Family Homes, who would be the people that would be building the villa homes. They spoke for about 45 minutes or so, and then there was some questions and answers from the public as well. The concerns that I shared earlier were prominent at that meeting as well, and continued to be brought forward by the residents. Within the report itself, I did highlight a couple of things of research that we did over the last couple of weeks here. One of the questions that had come up at the last subdivision or the last meeting, was the effect on the property value itself. How might this affect property value? And property value can be a very subjective thing. We contacted Dakota County Assessor's Office to learn a little bit more about how property value is conducted and how they would make assessment in this case. While they didn't give us any real specific information related to Wallin 18th Edition, they did share how they come about in making determinations on property valuations. Essentially, homes of similar sizes, quality of construction, architectural style become a factor determining value. Those are their comp group. Homes that differentiate from the norms that may be established within a neighborhood may have an effect on that value. Homes in the closest proximity to that change are going to have the biggest effect. The furthest you go away from that, the likelihood of effect becomes lessened. And so that's what we had learned from the Dakota County assessors. Now, the project itself is a villa home style, and I'll go through exactly what that means. These are some elevations of the subdivision themselves. I'm sure you've seen these before. These are single-family homes, one-story homes, foundation sizes 12 to 1,700 square feet. Many of these would be lookout lots, which would have the possibility for finishing of a basement area, which could raise the square footage larger than that. Fieldstone has identified the price range for these finished homes to be between $390,000 and up to near $500,000 within the development. So a couple of images of what those homes could look like here. Lot sizes within the development. This shows what the proposed lot layout would be here and the lot sizes of the adjoining area. So everything here in red relates to what's proposed within this subdivision here. Lots would range from a low of about 7,700 square feet to a high of 19,700 square feet. Within the R1 zoning district, which this property is zoned, the minimum lot size is 9,000 square feet. So we do have 3 homes here that would be below that. I'll get into the clustering here in just a moment. And then you've got homes within the existing Wallin subdivision. The ones in white here are still owned by Wallin. The ones in black are owned by others. So these are generally homes that are owned by private individuals here. So you can see the lot sizes within the rest of the Wallin development are larger than these. They run between about 14,000 square feet on up to close to 40,000 square feet. You can see that the homes that are immediately adjacent to the existing homes here are the larger homes within there. They range from 12,000 to 17,000 square feet, the ones that are immediately adjacent to the development. We take a look at the clustering of the subdivision. As I mentioned before, this is a cluster subdivision. What exactly does that mean? We do have a permitted use in the R1 zoning district that allows for properties to be clustered. What that means is that cluster developments can allow for a variation of minimum lot and yard sizes while maintaining the overall density of the zoning district. Cluster developments are intended to preserve and enhance open space and natural amenities. And so in a situation here, we take a look at the properties themselves, ensuring that they are still above the 9,000 square foot minimum lot size on average, which they would be here. The average lot size would be about 11,600 square feet. This in turn would allow for some deviations on the size of the lots and some of the setbacks within the lots itself. And one of the things that the cluster development ordinance points out is that there's the preservation of natural amenities and open space. In the yellow areas here are tree save areas. Primarily this one here probably has the most in it. There's some trees down here as well. They total about 32 trees in all. These are trees that are proposed for preservation above and beyond what was proposed in the Master Development Agreement originally back in 2002. One of the key questions that came up at the last meeting is our legislative authority, and what authority do we have as a council and as a group here to approve or deny a subdivision. So we did a little more research on that. I talked to some land use attorneys on it. I've pointed out in the staff report, our state statutory authority, which is within there, and also some other advice I got from other attorneys. When the city council is reviewing a subdivision in this circumstance, they're acting like a judge. It's what's called a quasi-judicial capacity, which means the law that's established, the subdivision code, that's the term of what's being reviewed. The application is the evidence. And so you're taking the evidence of the application, applying the law to that, and making a decision based upon that. So as a judge, you have more, your discretion in a circumstance like that is more limited because you're looking as to if a subdivision meets the terms of the law within the subdivision code, you have an obligation to approve that. It's different from other roles that a city council may play, which may be more legislative, in situations where, for example, you're establishing a subdivision law. You have much more flexibility there in making determinations as to what you want in the law, but ultimately when you're in a position to enforcing the law, you're in a position where you have to take a look at the application. If the application meets the law, then the obligation to approve that comes forward. And so we asked some land use attorneys, particularly with the League of Minnesota Cities, for comment and experience and guidance on these type of circumstances. They reiterated what I had just shared with you, that when you take a look at the authority of the city council in applying a subdivision code, they have to take a look at the facts, make a decision based upon that. If they find that the subdivision does not meet the requirements of the subdivision code, they must specifically state findings of fact that would state why it's not in support of it in order for that to move forward. When you take a look at some of the items that have been brought forward as concerns, things that we've heard, things like conservation of building value, appropriateness of land use, these appear to be legitimate factors for review. However, in review with League of Minnesota Cities attorneys, they acknowledge the denial of the application based primarily on that value may not be sufficient, and that determination of property values can be somewhat subjective. What they told me in essence is that you got to have very succinct evidence in order to deny an application here. And when you're talking about valuation, that could be much more subjective. When you're talking about other things related to appropriateness of land use, those become more subjective as well. So a stronger case can be made for things that are more succinct. And that's what we had learned from our review from city land use attorneys on this. I included in your packet some of the history as well. We've been to the city council a couple of times with this application. We've had 2 neighborhood meetings on this. We've been before the Planning Commission on a couple of different occasions. With the Planning Commission, we did have the Planning Commission review the revised application shown here on August 27th. The Commission did vote on a 4-to-1 vote to recommend approval of the subdivision as presented before you tonight. And that was consistent with the recommendation provided by staff, which was also for approval of the subdivision. So before you in the packet, I do have the resolution for approval. I could stand for any questions that you may have. Thank you.
Thank you, John. Appreciate that update. Now, I understand the developer's here with a guest. Is that true?
Yeah, we had a value analysis done by a gentleman named David Arden. He's here to answer any questions you have about the report that was forwarded to members of council and posted on the city's website on Friday.
Okay. Thank you very much, Council. We have that report. What I decided to do is, I don't want to rehash the last meeting because I think we've all become fully informed on the issues. However, I'm going to allow testimony tonight on people who may want to speak if they have something new to bring to the table. And so I'm going to allow any testimony that people feel that that's new that we didn't have the last time. Okay? And at the end of, I'm going to start with the residents first, and at the end of that, I'll let the developer comment, and then we'll bring the discussion to the DS. Okay, so is there one who would like to speak? Okay. Oh, thank you. Thank you for being here at the meeting. And as usual, we have to give our name and address for the record.
Thank you, Your Honor. Anna Prettyman, Prettyman. My address is 1655 Fallbrook Drive. I'm a resident of Wyndham Hills. It's my position today, and I'm speaking on behalf of many of my neighbors who are here, the residents of Wyndham Hills. We urge you to deny the preliminary and final plat for the proposed development this evening. This afternoon, I submitted a 5-page document, some correspondence that I had put together, answering questions that the council had had from our last meeting. One of the reasons why we tabled this issue and are coming back here tonight is because we were looking at the statute, which Mr. Heinzman correctly pointed out. The particular statute that we're looking at is 462.358, subdivision 3B. We're looking at the review procedures. It states that a city must approve a preliminary plat that meets the applicable standards and criteria contained in the municipality's zoning and subdivision regulations, unless the municipality adopts written findings based on a record from the public proceedings why the application shall not be approved. I've laid my arguments out in my letter, and I will highlight them for you this evening. It's our position first that the application before you does not meet the applicable standards and criteria in our zoning and subdivision regulations. The alternative argument is if you find that they do meet, the application does meet the zoning and subdivision regulations, it's our argument that you still deny the application because I'm going to give you specific findings of fact to deny it, and I'll get to that at the end. I first want to address the issue that the proposed development does not meet the requirements of the city's subdivision regulations. In reviewing a subdivision, the council is charged with considering whether the layout of the subdivision is in harmony with the existing plans affecting the development and the surroundings, and it shall be in conformity with the city's development objectives in the entire area. This language is out of City Code 154.05, Subdivision A. To approve the proposed development, the council must find that the development is compatible and is harmonious with the adjacent land use, specifically the existing neighborhood. We are the existing neighborhood. As you are all well aware, The proposed development is located adjacent to an area that was carefully planned and developed over a number of years and is now referred to as Wyndham Hills 1st through 17th editions. I live in the 14th edition. When our existing neighborhood was platted, the property was encumbered with both public and private restrictions that guide the development and create uniformity for the entire neighborhood. Mr. Curtis Garretts submitted, I believe by email last week, a declaration that he had that when he built his home last year. There's a number of architectural design standards in those bylaws and covenants that he submitted to you. Those similar ones apply to my own home that I built as well as many of the neighbors here. The covenants provide the basis under which the residents of the existing neighborhood built and how we invested in our properties. But now there's been a change. Until recently, the agreed-upon plan for the proposed development was consistent with the long-standing standards of our existing neighborhood. In fact, in 2002, as part of the Master Development Agreement, the developer committed to finishing the proposed development area by constructing 9 single-family homes. Now they want to change the rules, and they want to construct 14 villas that will look and feel quite different than a single-family home. How are they different? This is how they're different. The homes in the proposed development will have a main floor finished square footage ranging from 12 to 1,700 square feet, which is a significantly smaller footprint than the homes in the existing neighborhood. Second, the rules and the regulations that are proposed do not impose anywhere near the same level of standards as have been imposed on lots in the existing neighborhoods. I was at that neighborhood meeting last Thursday. I asked whether the developer would consider building less than 14 villas. The answer was no. I asked whether the developer would negotiate with myself and some neighbors to talk about the exterior of the homes, how are they going to look, and whether they would meet some standards that are similar to our own homes. The answer was no. They are non-negotiable on this. As a result, the proposed cluster development design, together with the lack of consistent minimum standards, creates a conflict with land use in the existing neighborhood and is not harmonious with it. Second, the proposed development is not properly characterized as a cluster development. As you are well aware, the application has been submitted as a cluster development, which is a permitted use in the R1 zoning district. The goal of cluster development is to preserve and enhance open space and natural amenities. But the description by the applicant of this being cluster home development is misleading. While calling the proposed development a cluster development allows them to reduce the setbacks, the developer is not proposing to, in fact, cluster the homes together to create more open space. While the staff report does note that there may be some more mature trees that are going to be saved, these resources could still be preserved through the traditional plat application. In other words, we could still save all these trees if we had the original 9 homes that we contemplated. We believe that the developer is not proposing a cluster development to allow for the special preservation or enhancement of natural resources, but rather to enhance the economic return that they will see by increasing the number of homes from 9 to 14. Third, there are serious traffic and safety concerns under what they are proposing. If you look at the map of what is the 9 single-family homes from 2002, there's and where those driveways dump out, there's enough space and reasonable space for a homeowner to back out of their driveway, turn around, and be able to get onto the pathway to look onto General Sieben and figure out whether or not they should approach. Under the proposed development, it's very concerning to me that there are a number of driveways clustered very close together by that pathway. So what we're going to run into is homeowners going in and out of their homes, somehow having to turn around. Perhaps there's other people in the cul-de-sac coming up behind them, and I think it's going to create some traffic concerns of them having enough space to be able to look for oncoming traffic or people that are going to be using that walkway right there. The City Code Section 154.05B expressly requires that the design of all streets be considered in relation to not only the existing and planned streets, but also to the circulation of traffic. I don't think that that has been done in this case. The fourth point I want to raise is that the City Code is very mechanical in what it requires to get here, and the council is well aware of that. It does require a declaration of covenants to be filed, as well as a provision for the formation of a property owners association to maintain the common spaces. The developer is proposing they're going to have a homeowners association take care of the snow removal and take care of the grass. However, I reviewed the city file. I did not see any type of specific provision establishing that homeowners association. And the city code lays out what is required, and I have not seen it in the city file. In addition, the city code requires that there be a declaration of covenants filed. I haven't seen it in the city file when I reviewed it. When I went to the neighborhood meeting last Thursday, I was given a one-page document called Architectural Restrictions on New Construction. I believe Mr. Garrett submitted this in his email last week to council. There's only 9 standards that they are requiring on these villas. My home has pages and pages of high standards that were required for us to build. This is a huge discrepancy. A, I don't think it's filed, which it should have been. And second, it certainly does not conform and it's not in harmony with our existing homes. I do want to talk about the standard of review because that's been alluded to tonight. In Minnesota, land use decisions, including whether to approve or deny a plat, are made by local governments, which is you, because you elected officials are the ones who best understand the goals of our city and the objectives of the community who will be affected by this development. Your decision is afforded great deference. That means you're the fact finders. It's up to you, it's up to us to give you the facts and the evidence. It's up to you to look at those, apply the law. And so long as what you're doing is not arbitrary, it's not capricious, a reviewing court is going to say, job well done, and we will affirm what you have done. There's case law that talks about the cases Trisco versus City of Waite Park, 566 Northwest 2nd, 349. It's a Minnesota Court of Appeals decision from 1997. It's laid out in my materials on page 3. The Minnesota Court of Appeals has held that if at least one reason is given for denial, it satisfies the rational basis test, then the denial of a land use decision is not arbitrary. I'm going to give you 5 tonight. You only need 1 for it to be reasonable, and you can deny this application. I also want to talk about the fact that there has been quite a great showing of neighborhood opposition to this plan. Case law has held that while neighborhood opposition alone is insufficient to justify the denial of an application, courts have held that a city may consider a neighborhood opposition if it is based on concrete information. So it does matter that we're here, that we have a petition signed. I submitted one 2 weeks ago. I think it had 44 signatures on it. I have a second one tonight. It has 21 signatures on it. There's people here this evening that are opposing that, and that stands for something in addition to the findings of fact that I'm going to give you. So to summarize, we, the residents of Wyndham Hills, we don't oppose the 18th edition being developed. We all bought into our homes knowing it's going to be developed, but we bought in knowing that it was going to be 9 single-family homes, and now it's increasing to 14 tiny townhomes. We have all made a significant investment in our homes, and we did so in reliance on the fact that the remainder of our neighborhood would be developed in a manner that is consistent with the master development agreement and is consistent with the standards that have been imposed on all of us. Here are the findings of fact that I asked you to respectfully consider. Number 1, the proposed subdivision is not harmonious with the surrounding area because the proposed minimum standards will result in a development that is not consistent with the 2002 master development plan and the previous additions of Wyndham Hills. The second finding of fact, the proposed cluster development does not achieve the preservation or enhancement of open space that is required by the code, and instead, it simply increases the density that can be achieved by this developer. A third finding of fact, the proposed development will result in an increase in traffic that has not been addressed by the proposed layout of the roads. Number 4, the proposed development fails to address potential impacts on traffic and safety created by the addition of additional driveways within close proximity to the cul-de-sac. We're talking about 5 more homes going in this tiny cul-de-sac. That's a lot of traffic. I mean, what do you think? Each home probably has 2 cars. The developer can't control who they're going to sell these homes to. They say they're going to market them to to empty nesters, but it could well be people with kids, like my family, who want to ride bikes. My husband and I both have a car. And that's more people in this area going in and out of Brandlewood Court and jumping onto General Stephen Drive, which is very busy. The fifth finding of fact that I respectfully request that you consider is that the application fails to address specific code requirements related to a declaration of covenants and the homeowners association. That's mechanical. That hasn't been done. So for those grounds, I respectfully request that you deny the application in its entirety tonight. If the council has no questions for me at this time, I will end my comments. Thank you.
Thank you for your testimony. It's appreciated. Council, any questions? Okay, thank you.
Thank you.
And I'm going to take testimony right now. You will have a chance to respond. Okay. Is there anyone else from the neighborhood with new information? Name for the record. Welcome to the meeting. We're glad to have you here.
Thank you, Mr. Mayor. My name is Curtis Garretts. I live at 1771 Greystone Road. I'm going to keep it brief. Number one, thank you, Mr. Rapp, Mr. Wallin, Mr. Johnson, Mr. Hinsman for holding that meeting last week, Thursday. Certainly appreciated. We're able to answer get some questions answered. I'm not going to go into detail about the document. I'm going to trust that everybody, the council members, read the documents that I sent, so I'm not going to go over them or review them. If you did have any questions, I'd be feel free to take them. I moved here 6 months and 9 days ago from a neighboring town. Never once did I think I'd be sitting in the city council chambers doing something like this. To myself, it's almost a little bit heartbreaking. However, certainly appreciate the job that you're doing, and certainly looking out for what I signed up for, where I moved to. The one thing that actually was new to me that I saw tonight, which Mr. Hinsman posted up on the screen for us, was the preservation of the 32 green trees, the 32 existing trees that were going to be kept due to the new cluster development. I don't have the map of what was presented or what would have been preserved with the old or the original 9 lots that were proposed. I can say, because of my lot bordering lot number 6, the trees that are being preserved are in a space that essentially is undevelopable. It's a portion that all of the neighboring developments all drain into. In fact, right through our yard is a setback for essentially a storm sewer pipe. I have a setback that I have to follow with my house to stay away from that storm sewer, which comes back to another storm drain, which essentially is maybe about 100 feet off the rear of my lot to the south. I'd be very interested to see what that map would look like and if those trees would be preserved anyways with the original 9 lots. I don't think we're preserving them because, quite frankly, it would take a tremendous amount of effort and a tremendous amount of money to develop that area where those 32 trees, that yellow highlighted section is. I just wanted to bring that to your attention. Just this morning, I received a surprise phone call. Before we built, our lot was actually on hold. It was surveyed and ready to be built upon, and that apparently fell through. The phone call I received was from the gentleman and his family that were going to build there. What they stated for me is essentially that there was so much going back and forth with the style of their house that they essentially said, you know what, we're going to stop this process and we are going to just move into an existing home that was for sale in the neighborhood. He said, Curtis, I feel for you. At the same time, I can tell you with great confidence that I'm so glad that I did not build in your lot because I did not want those going up in my backyard. I don't have that in writing or recorded, which I shouldn't have anyways, but I just wanted to share that conversation that I had just this morning with you. I don't know that it's pertinent or not. I'll ask the council members if you think it is for everybody to come up and state their name and address. If not, what I would like to do is maybe have everybody in the neighborhood that is opposed to it here today, since there is a lot of folks here that we don't know what they are here for. If
We'll
they
just
could-
have a show of hands, so.
Show of hands, or
I'd
actually,
like to go a little quicker.
absolutely, that's why I'm
We
asking.
had the
I think
public-
that's,
we
you
did-
bet.
This is not a public hearing,
bet.
but we've had 2 hearings, and.
And that's why I ask. I think it'd be appropriate, maybe everybody stood, just to show your
and I
opposition.
can probably tell you what I think the result's going to be. So go ahead and ask the question, Curtis.
Is that okay if they raise their hand?
Please, there you go.
If you are in opposition, could you please raise your hand with this development?
Thank you.
Thank you. And with that's all I had. I just want to thank you very much for your time. I know that this is a very difficult decision for both of us. There's a lot of emotion from both sides. I do feel that it's pretty nice to have the folks here that voted for the council members here to be present to ask of you to please represent us in the most fair way appropriate. So thank you very much for your time, Mr. Mayor and council members. I appreciate it.
Thank you for your testimony. I understand we may have one more? Okay. Welcome to the meeting. Glad to have you here.
Good evening. My name is Jill Gens. I live at 1671 Fallbrook. And I just have a few pieces of new information. I'm not going to take a lot of your time either. Anna did an excellent job highlighting the most important parts. First, I just want to thank you for hearing our concerns and listening to our comments. I'd like to acknowledge the tough work that you do while representing the community of Hastings. We have elected you to be our voice and to allow Hastings to flourish and to continue to be the place that we love and know it to be. I just want to point out a few important things, namely, Mr. Rapp happily stood before you at our last meeting to boast about the accomplishments and accolades of Fieldstone Family Homes. He even reminded us of the positive relationship that his client has had with both the city of Hastings and other communities such as Farmington. However, I find it particularly interesting how Mr. Rapp failed to mention what Mr. Trent Johnson and Mr. Troy Johnson and Mr. Brian Wolf were doing around the years of 2008. When calling to speak to the representatives in the offices of Fieldstone Family Homes, it was confirmed to me that these are the same 3 gentlemen who operated M.W. Johnson Homes, a company that filed bankruptcy around 2008, with between what the Star Tribune reported as 200 to 999 debtors and millions of dollars in debt, only to open their doors as Fieldstone Family Homes just shortly thereafter. Imagine the devastation when local subcontractors went unpaid while Fieldstone began its operation. Upon further investigation of Fieldstone, there are numerous records that seem to indicate a very recent history of many failed city inspections, no-shows with city inspectors, and refailed inspections time and time again through Hastings and throughout Farmington. Instead of outlining these infractions, I am providing copies that highlight just a few of the recent developments where this can be shown. What's more concerning is that these Fieldstone Family Homes inspection records seem to be eerily similar to that of M.W. Johnson Homes, which I am also providing for your review. So if indeed these are the same business associates, I would ask what has changed and what will be different for our constituents in Hastings. Is this what can be expected when Fieldstone Family Homes begins this potential project in Hastings? How can we be assured of any consistency, quality, or compliance from this organization when they have what appears to be a track record of failed inspections across multiple cities and former millions of dollars in debt? Is this the way in which the city of Hastings intends to attract customers? Spend only a few minutes online reading of Fieldstone Homes and you will most likely discover contention. Conversely, I might add that when obtaining a record of a local builder in Hastings, you can see that the number of infractions is next to none when meeting inspection requirements. I have provided that for your review as well. It is my understanding that City Code 15405 Part B states that design standards shall harmonize with existing plans and surrounding areas. How should the City of Hastings offices, building inspectors, and residents feel about a company building in our wonderful Wyndham Hills community when M.W. Johnson and Fieldstone Family Homes, either or, have a track record of bankruptcies, online negative reviews, and multiple and repeated building code inspection failures? The residents of Hastings have chosen you to be our voice, the voice that hears and responds to the concerns of its residents, and I'm hoping that you'll show us your support with a vote of no tonight. And with that, I'd like to just hand over the city inspection reports. These date back to 2003 for both M.W. Johnson, when it was under operation of what I understand to be Brian Wolf, Trent, and Troy Johnson, who is now the same, the way their office has explained to me, the same three gentlemen that are still operating this business today with the same failed inspections. So could I hand these over? Thank you for your consideration.
Okay, we've heard testimony from the neighborhood. We'll hear testimony from the developer. Based on new information, please come to the podium. Welcome to the meeting. Glad to have you here.
Thank you, Your Honor. Mayor, members of the council. I have to stop for a moment and just comment, and I think it's only fair that this council give Trent Johnson an opportunity to defend his name and reputation because it has been trashed. Suggestions that Fieldstone Family Homes has ever been bankrupt, I believe, is preposterous. The notion that Fieldstone Family Homes has left millions unpaid is preposterous. Those are serious allegations. Those are economic accusations. They're false, and they're defamatory. And apart from the fact that they play no part in a determination of whether this council should or should not approve the Wallin 18th edition, it should not stand to listen to those accusations of a defamatory nature against a business. People should not be subjected to that in this community and by its residents. It's very, very disheartening to hear those false accusations made. There have been also false accusations made with respect to what we're proposing. Ms. Prettyman referred to them as townhomes because they want to think of them as townhomes. But what we proposed is the development of 14 single-family homes in a cluster development. They are not attached. The definition of a townhome is an attached residential structure. So that's a misrepresentation, as is her representation that I only gave her one page of the proposed architectural restrictions. Gave her 2 pages at the meeting last Thursday night. We haven't drafted the covenants that will be applicable to the 18th edition yet. And with all the other subdivisions that we've done in this community, we haven't drafted those until we've had plat approval either. So it is preposterous that we should be attacked and that one of the 5 reasons presumably for a factual determination of denial is that we don't have our covenants done yet. As I understand it, drafting covenants is a condition of approval. We'll do it just as we've done it on every past occasion. And the homeowners don't get to decide what goes into those covenants. We do. We are the landowners. We have very carefully considered restrictions that we put into our purchase agreement with Fieldstone Homes. But it's our declaration, it's our values that we need to protect. Apart and in addition to the overall protection we provide for residents in the entire community. I do want to speak to these purported 5 factual grounds for denial that Ms. Prettyman referenced. The notion that this is not harmonious, I don't find that as a valid or enforceable legal requirement, and it is a value judgment. We are proposing, as community director, development director indicated, homes that are single family. They will be ranging in price of between $390,000 and $500,000. I circulated to Mr. Hinsman last week a study done by a 6-month snapshot of MLS listings of sales and list prices in the neighborhood. There were about 9 homes in the Wallin subdivisions that were listed for sale, 7 of them for less than what Fieldstone is proposing to build in the single-family cluster development that we've proposed. So I don't believe there's any factual grounds for a claim that the homes are not harmonious, nor is there any legal grounds found to deny our proposed plat on that basis. Similarly, staff has supported our proposal because we are protecting natural amenities, the 32 trees that, by way of historical fact, this project was preliminarily approved by the city back in 2002, and the site was graded and scraped of all vegetation, essentially. These are trees that have grown up since. They're not subject to any protection at the present time. If we did 9 lots in that subdivision, we would be able to scrape them off again because they're volunteers. What we've proposed to do is preserve them. And in the judgment of your community development director, that meets the test for a cluster development in your community. So the notion that Ms. Prettyman posits that that standard is not met is contrary to the staff opinion you've received from your own community development director. I remember standing in early August in front of the Planning Commission, and we took a tanning by your Public Works Director for our proposed additional lots along General Sieben Drive, in which we had proposed to have 8 driveways coming out on the General Sieben Drive. And despite the information that I provided that seniors are likely to have fewer trips per day and the actual traffic volumes entering onto General Sieben Drive, did not change his opposition to our proposed plat. So we changed it. We took those lots out of our proposed subdivision. And now all we have are lots within the cul-de-sac, which is already platted as Brandlewood Court. And there's not been one word of negativity or complaint or concern expressed by the Public Works Department of the City of Hastings that anything about having 14 lots in that cul-de-sac poses any risk of traffic or safety concerns or an excess number of traffic. So again, there's no support for that proposition before this council that rises to the level of any legal grounds for denial. And furthermore, General Sieben Drive is, as I understand it, a major collector street. So it is not inappropriate at all to have traffic from the cul-de-sac enter onto General Sieben Drive in a controlled environment, stop sign, just as it is the case with Cobblestone Court and Dell Ridge Court and the other cul-de-sacs that enter onto General Sieben Drive. There's nothing different there. And finally, the notion that the code requires covenants. We self-impose that restriction. We've indicated that's our plan. We endorse and embrace the notion in the approving resolution that staff has prepared for you that the property be subject to those covenants, and we'll draft them. And they'll be exceptionally similar in scope and content to the type of restrictions that have been applicable to other parts of this community. And so on the basis of what's been presented here tonight by the residents who have spoken, there is not legal grounds that's all of a sudden been discovered here that justifies a resolution of denial. The only lawful course, I believe, is for the council to consider the application, consider its compliance with your ordinances, and pass a resolution of approval. Thank you very much.
Thank you for your testimony.
And I did want to say that if you have any surviving questions about whether or not our proposed villas are going to create any danger to property values in the area, Mr. David Arbit is here. He drafted the report. He did a careful study. It's factually based, and it establishes the proposition that if anything, a mix of home types in a community enhances values rather than detracts from them. And I offer him to give a presentation if you feel that would be valuable.
Okay, thank you for that offer. Thank you for your testimony. Did someone want to speak one more time from the developer about the Fieldstone family home situation? I think Mr. Rapp, you had indicated that. Welcome to the meeting. We're glad to have you here.
Thank you. Trent Johnson, office address 801 Cliff Road East, Burnsville, Minnesota. Hadn't planned on speaking this evening, to be quite honest with you. We've just been kind of in the background looking to buy some lots to build a product that we saw a need for in a city. After completely having my name smeared in a place where I never expected it to be defamed, any careful research would have shown exactly what I was doing in 2008. In fact, from 1999 until 2010, it would have shown. A little bit of careful research through the Secretary of State, business searches, ownership in companies, anything like that. I've never been an owner. I've never been an owner of M.W. Johnson Construction. In fact, I was a subcontractor of M.W. Johnson Construction. I had companies that lost $250,000 when that all happened. That's what happens when you're in business, right? That's what happens. I'm not sure where you collected your information from, but it's dead wrong. So, that being said, I paid off all my bills. I took a second mortgage on my own home to pay off my company's bills, TJ's Group of Minnesota, operating as TJ's Landscaping and TJ's Waterproofing, both in the residential industry, doing business for large residential builders, M.W. Johnson included, and took off a second mortgage against my home, and I paid off all my outstanding bills to make sure all my subcontractors were paid, and then liquidated all my equipment and machines and everything, and went back to work and decided to start a new company. There was born Fieldstone Family Homes. So, to stand up here and defend something like that when accusations were made that I was in ownership of a company that failed and that I had left people on the table still with money owed to, is completely false and very reckless. I will be asking for a transcript of this to make sure there is no legal action that can be taken there, because that was a shot. So I do appreciate all the work everybody has put into this. We understand that it's a hard job. We understand everybody involved has a hard job. I also understand where you guys sit. I came in today thinking, you know, if we get this approved, I'm going to sit down with a few of the homeowners that asked us to sit down and say, hey, what are your touch points? What do you want to see on these houses? Because we have the choice. When we go to build, minimum covenants are minimum covenants. If there's something that's that important that this many people are willing to show up to, if it's LP, if it's hardy board, if it's a concrete driveway, if it's something that we can do to make the people happy, yes, we'll talk about it. But I did not expect to be attacked personally. Thank you very much.
Thank you for your testimony. Appreciate it. We are now going to have the discussion here among the council members. We'll bring the discussion to the dais. I appreciate everybody's patience and the civility. And we will now bring the discussion here. Council, we are open for discussion. What's your wish? Councilmember Vaughn.
Thank you, Your Honor. I'm the one that tabled it last week, or asked to have it tabled, so I appreciate you giving me a first opportunity to talk about it, because the number one thing I heard 2 weeks ago was the market value. This is going to affect my home value. I think what we've seen in our packets, Council, is that if it's not enough there. The Dakota County Assessor, the League of Minnesota Cities, they use the words may, likelihood, subjective, and I know we were looking for finding of facts. Personally, I just didn't see it there. I think the housing market is a market, just like my retirement. I got a house too, and hopefully the market is going to be good for my home someday. So I didn't, that wasn't there for me. I had to keep searching to say, what is it? The private covenants comes up next, and it said in our packet, the establishment and enforcement of private covenants is outside the authority of the city. Some residents, it's not just this developer, want the city to be involved, but it's usually when things aren't going well with the city or with the residents and the landowner. Again, I don't think we should be involved in that part of it. Then I go to this other side of the table, I look at the landowners. They're in it for a business. It's their business. We hear often sometimes the cities are too involved in our business, but unless I have a contract with the business and the business has the right to do what they want with their property, these guys, it's their land, as long as they're following the law. There's land developers may have agreements or contracts with residents, but they're building the home. We, the city, are not part of that covenant part. We're doing the zoning part of it. What's asked of us? We're asked to change the plot. The original master plan 2002 had single family, and they're asking to go to a cluster development. It does state in our ordinance that a cluster developments are allowed in R1. I get that. But the definition in the zoning book is that cluster developments are intended to preserve and enhance open space and natural amenities. We've heard that. We accept the variation of lot sizes and yards while maintaining the overall density. It gets me to the next part. I've listened a lot for the developers. I've watched them try to explain the proposed villas. I've even seen them put effort in trying to reach out to the neighbors. I give them credit for that. But I haven't seen a whole lot of compassion, I can tell you that, on me watching this, about what the agreements that they had with these builders. I've heard from the residents of what they had to go through. One thing I thought I would have heard, and I didn't ever see it, was there's no separation or even landscaping between the homes that were built and the proposed villas. I've not heard a commitment from that builder that they won't wait till 14 villas are sold, and then they'll build them. I don't even know if that's possible. But the role that I play through, let's say they sell 4 villas, and all of a sudden, they can't sell anymore. They're not going to knock those 4 villas down. I'm assuming they would drop the price. Again, now we get back into property value. Let's say they do sell all 14. I can almost guarantee they'll be back in front of us saying, that worked out well. Let's try to redo some more cluster developments because I think the development works. They want to build more single-family homes for the rest of the development. We're back to the wordsmith, a villa is considered a single-family home. I get that. Here's where I'm going to conclude, Your Honor. We have seen and told by the developer did not tell residents in this area that they may propose villas or cluster developments in the last year or maybe never. Again, that is a business decision between the developer and the customer, which is the residents who we represent. Here's my hang-up with the cluster development. It is proposed to create a low-impact development that groups residential properties in a proposed subdivision closer together in order to utilize the rest of the land for open space, recreation, or agricultural. This developer is not proposing to utilize the rest of that land. Now, we're not talking about the trees part of it, the land, because they're going to sell it. They're going to sell them to people with a family, with the home. And I don't see the recreation side because we've seen in the minutes that they use the rest of their park dedication dues and put that in lieu of land. They sent that over to the park dedication fees. And I just don't think agriculture is going to work in this area. In defense of the residents, this is where I'd like to listen to more. This cluster development did not hit the definition and purpose. And that's where I want to end because I just don't think that's where I home up on what the definition of a cluster development is, and I don't think this development hit one of those 3. Thank you.
Okay, further discussion. Council? Councilmember Fulch?
I got her on now.
Okay.
Thank you, Your Honor. Thank you, Councilmember Vaughn. I agree with, many of the points that you just made in regards to the fact that I don't believe either that the development is meeting the goals of clustering. And I don't believe that we ever did see a rendering of the development that would have shown the placement of the homes exactly on these lots. But I am presuming that where it would be, the saving of the trees, that it's very far back on these properties, and that I can't imagine that there would be any reason to clear those trees one way or another, even if they were smaller lots or larger lots, that those trees would have been left as they were. And so, in that respect, I agree. I don't feel that this particular development is meeting the goals of clustering, and I'm not supporting it for that particular reason. Thanks.
Further discussion? Councilmember Liefeld.
Thank you, Your Honor. I do have a question which might be best for Mr. Flegel here. So since 2002, Wyndham Hills Home has a very long-standing precedence of very strict covenants that all of these individuals who built their homes had to follow. To me, again, I run a bank, I'm seeing some sort of implied consent, some sort of implied agreement for everybody who is building there, who is purchasing their homes, that, boy, we've been doing this for 17 editions. All 17 editions did this. It's been since 2002. To me, that applies, or I guess that's my question is, what is that saying to all of the homeowners? I know Mr. Rapp made some sort of comment about the notion that the code requires covenants and that you don't have to do that. You chose to do that. I feel that 15, 16 years and 17 editions has set that precedence for them. So where are we at with that?
Thank you, Council Member. I think as to any agreement or a promise between the developer and the landowners, I think that is really outside of what the city can control. I don't know if those promises were made. There's a lot of people here that are saying they are. But I think that promise or the contract is not necessarily something the city can rely on. I think what you're getting at more of maybe a basis under the concept that was mentioned earlier, that a new subdivision coming in has to be harmonious or in harmony with the surrounding area. That is identified in the city code as I'll call it in a general intent statement. It's not a specific condition of subdivision approval, but it is contained in more of the intent statement that leads off the ordinance. So is it the strongest argument for a denial of the development? I would probably say it's not. But I think if you look to that, and if you make the determination reasonably that the failure to continue on with that overall plan with the similar homes and similar size homes and quality of homes, then I think that potentially could be used as a basis for a denial. Am I going to tell you that that absolutely would hold water if it's challenged? I can't go there, but I think that's what I would look to, is it doesn't meet that standard that is in that intent statement.
Okay, on the grounds that it's not consistent with the master plan based on their own precedences over the last 15 years.
And again, I'll try to get to the specific location in the ordinance, but yeah, I think it generally reads 154.05 design standards. Generally, design standards shall assure that the layout of the subdivision, that would be the new subdivision, harmonizes with the existing plans affecting the development and its surroundings, and shall be in conformities with the city's plans. So I tend to think that may be what you're getting at there, that it's not.
Councilmember Brox.
Thank you, Your Honor. I had many of the same observations as Councilmember Vaughn, so I'm not going to rehash what he said. But I think of all the issues that I've heard in all the meetings that I've attended and reading all the Planning Commission notes, the one that stands out to me the most is the same as what Councilmember Liefeld said in the covenants that were required of all the owners in this neighborhood, and likely those same covenants were kind of used to raise the standard of what this neighborhood was going to be. They were, the atmosphere and the neighborhood were part of what was being sold. When custom homes were being sold, I'm sure that was sold to the residents, that was going to be an important part about their neighborhood. So it's a little bit difficult, and I understand where the neighbors are coming from now that it doesn't necessarily suit the developer's interests, that they can change them. And if I was a resident in this neighborhood, that would be very frustrating to me, and I hear that. Now, the problem is, from a legal point of view, kind of what Dan alluded to and what Councilmember Liefeld asked about, any kind of promises that were made on behalf of the developer with the residents, that relationship to me is between the developer and the residents, and that doesn't necessarily involve the city of Hastings. So while there may be remedies for that situation, I'm not sure that a denial of the plat is the correct remedy for that specific issue. Now, that being said, I agree with Councilmember Vaughn that I don't see the cluster development purpose being met here, but my question is how many different things, how many different factors do there need to be in order for us to deny the plat? Because to me, that one is the only one that rings true with me. And I did ask John if we had ever faced something like this in the city of Hastings before, and he did provide me with some information about the site plan approval of the Whispering Lane condos that was in 2004 and 2005. It was a similar situation. There were some small differences. The Planning Commission had actually recommended denial of the site plan, and that was because they found the plat did not meet any landscaping or berming conditions that were supposed to be there, and there was an increase of traffic to the neighborhood. So there were 4, in that case, different findings of fact that gave the council a reason to deny the plat. And those 4 things were inconsistency with the comprehensive plan, inconsistency with the Hastings tree preservation guidelines, public safety and transportation issues, and a negative effect on the surrounding properties. So I guess my question is, and maybe this is a little bit for Dan, how many findings of fact are solid ground for us to deny a plat?
Thank you, council member. One, if you have one good basis as to why the application does not satisfy the requirements under the subdivision code, that is all you need. You know, there's this concept of, well, let's throw the kitchen sink in at 2, but I think what you want to, if the council is considering a denial, you want to stick to what is real and what is certain, so that your decision is really based on those items. So 1 is all you need. If you have multiple reasons that you think are legitimate as to why the application doesn't meet the subdivision ordinance, then by all means they should all be included in a resolution denying, but you really only need 1.
Thank you, I appreciate that. And I think for me, the cluster development is the only argument that rings true. There's been a lot of other ones. Is it harmonious? Does it preserve open spaces? Unsure. People are unsure about future development. Are these property sizes big enough? Are the houses too small? Who are the inhabitants going to be? What are the covenants going to be? And really, all I can really hang my hat on is the cluster development definition, because that's what's in ordinance, and that is what we have to follow. As much as I hear and understand a lot of the other concerns, I think our job as council people is to follow our own laws, and I think it's really important that we do that. If we don't follow our laws, then we don't give anyone else any reason to. So I think that it's important we follow our zoning laws, and if this falls into the category of insufficient to meet the cluster development rules, then I am in favor of denying the plat.
Councilmember Lund.
Thank you, Your Honor. Well, I think if this was a different scenario with different requirements upon us, this conversation would be long over. So I hope you understand where we are in that regard. And so we are not just reviewing this for an hour tonight. This has been well looked into, so we appreciate all the information on both sides as well. I think, you know, a lot of the things laid out, as Councilmember Brox just brought up, are a little bit challenging to really pinpoint that legal backing. There's a hint of it, but not enough necessarily to really be substantial. So, you know, emotion out of it, you know, that's where I'm sitting. So then we have to look at, okay, where is the information that's going to be able to be defensible from the position where we're at. And I agree with everybody has spoken so far that the cluster really is the one that stands out. Councilmember Vaughn did an excellent job recapping and stating the fact. So I appreciate that. Well done. And, you know, the harmonious aspect is something that is really hard to define. I don't know if being a single-family home is enough to be harmonious. That one's challenging, but I do think that the cluster is definitely standing out to me. I do not see this as an intentional cluster for the purpose of it being a cluster. I think this is an intentional cluster to find a way through the system, and so for that, I will not support.
Councilmember Balsanic.
Thank you, Your Honor. Villa townhome, 400,000. I don't know. There's a phrase that comes to mind in terms of listening to all this, and that phrase is lipstick on a pig. The nature of these, well, they're not up there anymore, but the nature of these villas just leads me to believe that they're going to be kind of transient. I have a question, but I don't think we can answer the question because that would probably get into the covenants, but if these homes could not sell for $400,000, could they be rentals? Could they be rented out? In which case you're going to have a lot of transient stuff going on. I've seen some of the townhomes here in Hastings. Some are very nice, some are very suspect. And I just don't see that somebody is going to come in and offer $400,000 for something that they would probably have to finish the lower level on. That's all emotional. That's all subjective on my part. It's not factual, but I see a kind of reality here with that. The thing I'm wrestling with, or had been wrestling with for the last couple of weeks, is the degree of the welfare that we have to look out for in a community. To what degree is the welfare important enough to deny? Well, looking at this, and I apply the same terminology again here, the lipstick on a pig, I'm sorry, but this business of trying to save green space and looking at how much green space we're going to preserve and what's going to happen with it is a joke. It just is not compelling to me, and therefore makes a bit of a mockery of the whole concept of cluster homes. I have a son who lives down in Rochester with his family. They have single-family homes. They're kind of on the same degree of what I think a lot of you are living in. And they have they have green space preservation there, and they have acres of green space preservation. We were down there for the weekend, and my son is showing me his trail cam pictures of a 10-point buck that is going through his backyard coming out of the woods that is the green space within that neighborhood. It's an ideal type of situation. I'm driving down General Sieben and I'm trying to find those trees that we're trying to preserve, and I don't see that much there. And the other thing, and again, this is kind of subjective, and I had written some emails to some of you homeowners who had written to me, and I had offered suggestions as to, you know, what could be done as a compromise, not just for the homeowners, but maybe to offer to the developer and the contractor what could be some compromises. Obviously, that did not work out. As I said at the last meeting, I really feel, and I remember when the developer came to the planning committee of the city council, of which I'm a member, and said, we can't get a contractor to come in unless we've got X number of homes that they can build. Well, evidently that number is 14. Now, that's not a disservice to the contractor. It's not any disservice to the developer. It's just, I think that's the way it is. I don't know whether the developer was offering, you know, to see whether they could find another developer who could build 11 homes or 9 homes so that the homes could be spread out a little bit more, could maintain larger square footage, and things of that nature. And then the business of the covenants, which again, we can't get involved in as a city. I've lived in areas where I was subject to covenants, but the covenants really don't mean anything. To me, I don't think they're worth the paper they're written on without money, financial backing, to put some teeth into what the covenants are. I don't know whether you as a homeowner group has talked about dues, whether you pay dues in terms of protection of those covenants. But over on Windham Hill Drive, you can't put a fence up. Well, somebody put a fence up. People got upset, but there wasn't anything they could do because they had no financial recourse to stop them on that. So this is just kind of fair warning that your covenants are all well and good and sound good, and I know you did what you were supposed to do when you put your homes up, but in terms of protecting those covenants, it's the money that really makes it count, really makes it stand up. After saying all of that, the degree of the welfare that is required as factual information to deny something, I think can be one item. And I find, as Councilmember Vaughn has said earlier, most articulately, that for a cluster development to protect green space, this is not viable. This is not compelling. I find the arguments of Anna Pritteman compelling. I don't find the plat to be compelling, and therefore I do intend to vote against this request. Thank you, Your Honor.
Okay, everybody's spoken. Councilmember Fulch.
Thank you, Your Honor. I believe that majority of us are in agreement about it not meeting the requirements of clustering, and I think that we have a strong argument, secondly, with it not meeting the standards of being harmonious to the neighborhood. I mean, all you have to do is look at the homes, the values of the homes and their square footages that are in the adjacent neighborhoods around River Shore, Timberview, Greystone. Those houses are very large and very impressive, and I don't believe that these villas meet the same standard. I think the argument that of them being able to fetch $400,000 apiece is probably rather aspirational. I don't think that, I think what's going to happen is that you're going to try to market them at that higher value because the homes that are all around it are worth so much. And then that would be the thought process. And I'm afraid that it just doesn't, what's being proposed here doesn't meet the same standards of those homes that are all around it, and perhaps not fair to those adjacent homeowners. And so I think that we have a strong secondary reason. So I think that we have two reasons that we can deny this particular plat. Staff in a write-up, though, provided to us some advice that perhaps if we chose to deny it rather than straight out and completely denying the proposal, that we allow the developer the ability to go back and replat at the original count that was approved for the development. And so I would look to our legal counsel, Dan, as to what a motion might look like if we were going to propose something that would be similar like that. If it would be, a motion to table to allow the developer to modify the application and replat, or if we deny it, if that forces the developer to go through the entire process all over again, whether or not that's fair to them.
Thank you, council member. I think if there's a denial, then the developer can always come back and start the process over again. They would have to pay the application fees, submit the application, but basically this process would be done here and they would have to restart. I think with what you, council member, were identifying as two reasons for denial, one being the clustering, it seems to me that it would be easier for the developer to come back and potentially cure that issue with a different design. If they are able to submit an application that doesn't rely on clustering, that just simply meets the minimum lot size of 9,000 square feet per lot and all of the setbacks, then I think it's more likely that the developer could submit an application that doesn't rely on clustering and then would most likely meet all the requirements and potentially would have, I won't say have to, but would be more likely to be approved. I think the second issue that you mentioned, that there is just this disconnect between this type of villa development and the rest of the overall development, is less likely probably to be cured by some simple revisions to the plat design. If the council was inclined to deny only on the clustering issue, and obviously the developer has gone along for a period of time with a staff recommendation that supported the clustering based on what was there. It's ultimately your decision to decide that, but that was the staff. That's where I was coming from in the concept of, would you want to give the developer an opportunity to redesign and come back? So I think to the extent that you are considering denial based on those two different points, I don't know that I would consider the option of tabling and allowing to come back with a revision, because it's going to be harder to overcome what the denial was based on. If the decision is just to deny based on the cluster development not meeting those things, then maybe that's something that could be cured with a redesign more easily, and maybe it would be fair to let the developer do that. So, I think you have to decide what is the appropriate way to deal with that. It's cleaner to deny probably and require that the developer comes back, but I think I would leave to you how you would best handle that. Does that make sense? Not really? Sure, yeah. Okay. I think, let me just go back.
Just the one fact of finding.
A denial is a denial, and the developer would have to come back with a new application at a different time.
Okay, council, we're still in discussion. Is there a motion on the floor? Councilmember Vaughn.
Thank you, Your Honor. I make a motion then to deny the preliminary and final plat of 2018-35 with the finding of fact of the cluster does not meet the criteria of the open space, recreation, or agricultural.
I'll second that.
It's been moved and seconded that the application be denied. Findings of fact is that the clustering proposal does not meet the original clustering ordinance as you described it. That motion is now before the body. Is there further discussion to the motion? Councilmember Brox.
This is not specific to this development per se, but I do want to say, there's a little bit of devil's advocate in me. The mixed-use development is really in our future, as we've looked at the Vermilion Street Corridor Plan, and a lot of the Vermilion Street Corridor Plan recommends retail and housing in the same buildings, in the same units. And as I look around at other communities that are building quickly, I do see a lot of mixed-use developments where there are townhomes next to single-family homes, next to apartment buildings. So I guess the only thing that scares me is I don't want us to send a message that mixed-use development is not welcome in Hastings, because I think it is. But I think it needs to be in the right area and with the right timing. So this doesn't change my position, but I guess I don't want to send a message to future developers that we're not open to the concept, because I think we're going to need it, especially when we start working on Vermilion Street. So that's all I have to say.
Okay, is there further discussion to the motion before the body? Councilmember Balsanic.
Oh, thank you, Your Honor. No deference to, I believe it was Mr. Johnson, who spoke in terms of his credibility and so forth in the face of some documents that were presented. 2008, those were very tough times. 10 years ago, we were suffering as a nation the worst economic crisis since the Great Depression. And all you had to do was open up the Sunday paper yesterday and read about a half dozen articles and commentary about how horrendous things were. Just to say that in terms of your credibility, I am looking at the economic situation from those 10 years ago and since, coming up to today. And if there was offense on the part of anybody towards your reputation, I don't want to say it's fake news, but we see the political commentary, we see the commercials on TV. You're always open, if you're going to be working with a public body, you're always going to be open to criticism. And all I can encourage you to do is let it roll off your back. Thank you, Your Honor.
Okay, counsel, is there further discussion for the body? Seeing none, all those in favor of the motion say aye. Aye. Those opposed, nay. The motion prevails. Next, John, why don't you give us direction on the next resolution, the vacation?
Sure, Mayor, council members. The next action we have before you tonight is the vacation of easement for Wallin's 17th edition. Again, this was done in conjunction with the plat proposal. So at this point, since the plat has been denied by the city council, I would recommend that the resolution for vacation of easement also be denied.
Council, we have our direction. May I have that motion? Councilmember Vaughn makes a motion to deny, seconded by Councilmember Fulch. That motion is before the body. All those in favor of that motion say aye. Aye. Those opposed, nay. Motion prevails. We have a resolution before us, a site plan, Intek parking lot expansion, something that I hope is not as controversial.
Thank you, Mr. Mayor, City Council members. I'm ahead one site plan here. Excuse me. There we go. We have a proposal before us from site plan for from Intek for a site plan expansion at their existing facility on Spiral Boulevard. This is the existing map here. This is what they're proposing to do, and that is to add a parking lot of about 30 spaces back along Millard Avenue and then a new entrance road which would align up with this current driveway entrance at Green Lawn to serve this greater parking lot area. What's shown here is another similar expansion they did in 2016. So we did have the Planning Commission review this application. They did recommend approval of it at their last meeting with limited discussion on it. Staff also supports the approval of this as well, and I can stand for any questions.
Thank you for introducing that item. John, Council, what's your wish? Councilmember Liefman makes a motion to approve, seconded by Councilmember Brox. This motion is before the body. Discussion to that motion. Seeing none, all those in favor of that motion say aye. Aye. Those opposed, nay. The motion prevails. Next, we have a resolution, Pleasant Hill Library Addition, 1490 South Frontage Road. John?
Thank you, Mr. Mayor. City Council members, this is a small addition to the Pleasant Hill Library, and about 1,500, 1,600 square feet altogether. And this is what we're looking at here. This is the Pleasant Hill. No, it is not. We'll go to the Pleasant Hill Library, which is down here. The expansion area, and also the screen's not up too. So all the people playing at home can see this, but nobody at the council chambers. So within your packets, there is a 1,600 square foot area in the front of the building along South Frontage Road. Presently, right now, it's a landscape area. That would be filled in, be part of the building addition, which is part of a greater renovation project at the library that you're aware of. And then the landscape area would be relocated to the outside along with the patio area. So Planning Commission did review this at their last meeting, recommending approval on it at a 7-0 vote. Staff recommends approval as well, and I can stand for any questions.
Thank you, John. Appreciate that. Council, what's your wish? Councilmember Balsanic makes a motion to approve, seconded by Councilmember Fulch. That motion is before the body. Is there discussion to that motion? Seeing none, all those in favor of that motion say aye. Aye. Those opposed, nay. The motion prevails.
Thank you.
Next, we have under administration, city purchasing policy that was pulled off consent calendar. Councilmember Fulch.
Thank you, Your Honor. I was surprised that it hadn't, the new purchasing policy hadn't gone through any of the council's committees for any kind of consideration. 3 of us are new to the council, and we haven't ever really been debriefed about what are the city's purchasing policies or procedures to begin with that said in the write-up that this was a new policy. And furthermore, when I was looking at what the delegations were, I'm sorry, I've lost the page because I was scrolling through the entire packet. It only allowed for department heads to approve purchases under $5,000 that have been pre-approved within the budget, and then $5,000 to $175,000 needed to be approved by the city administrator and department heads. And so I thought that that was rather restrictive. I mean, I would recommend allowing for department heads to have greater purchasing power than that they would be able to sign off up to a greater amount, you know, anywhere, I would say between $30,000 and $50,000, you know, as individuals, if it's already been pre-approved. And because they're already delegated a great deal of authority. If the councils will approve that within the budget, I would see that that would be an appropriate action. And so I would just, I think it's maybe perhaps too restrictive, and I think that it should allow a little bit more professional, you know, judgment on some of the department heads to be able to do that. And so I would, I'm not sure, I'm not sure how to make recommend a change to the policy on the fly like this when we haven't had any background, and I'm sure that a lot of the other council members probably aren't aware of the changes that have recently occurred within, you know, the purchasing laws. And
okay, yeah, let me let Melanie have an opportunity to talk about it. And this is coming from Melanie Lammers, our finance director, and give a little bit of history on it. At the end of that brief history there, if we feel it's necessary to send it to administrative committee for a review, we'll find out. Okay, but I think the next course of action would be something like that, instead of trying to amend things on the floor here with just this right in front of us. Okay, Melanie?
Thank you, Your Honor and Council. This policy is actually procedures that have been in place for many, many years. Really, the only substantial change in the policy is the purchases over $175,000 coming before the city council for approval, and that is because state statute limit has increased. It was previously 125, it's been increased to 175. So what we're actually doing is just memorializing our current practice and procedures with that small statutory change.
Okay. Comment on that, or Councilmember Fulch?
Sure, I'll comment on that. Actually, the purchasing statute had said that it was any purchase that was over $100,000 needed to be approved by the city council, and it has just recently changed this last legislative session up to $175,000, which is a pretty big jump. And a lot of that had to deal with the fact that construction projects are considerably more, and it was also allow greater flexibility within cities to be able to, to make those authorizations without the council approval. And so I guess what I'm saying, though, is we haven't had a chance to talk about it, to learn about what are the city's purchasing procedures and be fully informed. And then, and to have that dialogue as to what would we, feel is perhaps more efficient for the department heads to be able to sign off on their own. I work for a city, Councilmember Vaughn works for a city. And so I just thought that the $5,000 limit for department heads to be able to sign off on their own was really very low. So, so with that said, I mean, if I were to, make an amendment, it would be to allow greater flexibility for purchasing, for the department heads to have greater flexibility in making those judgments within them. Like I said, $5,000, boy, you can barely buy anything, and it's over $5,000. And so it just seems like it's perhaps maybe not as efficient as it possibly could be. But, so.
Yeah. Julie, did you want to make a statement?
I do. Councilmember Fulch, I completely understand. What this practice is basically a sign-off. Our department heads have all the flexibility within the budget that they're afforded to purchase things as the council approves them. This is merely when we do our pay vouchers every week or 2 weeks. We've always said that anything over $5,000, the city administrator wants to see for a number of reasons. It kind of helps us keep track, too, of when we are getting our capital items bought. And so she just has a better idea in her head of when stuff gets done. But it has nothing to do with taking away the authority of the department heads. Does that make sense?
No, I understand fully that she would have to sign off on any contracts that were, or any purchases that were over $5,000. And so, so if that's the way that it always has been, I guess it is what it is. Just being a staff person myself, I would see the benefits of being able to allow a greater limit for department heads to be able to sign off. I just wanted to support our leaders, within the various departments, and to allow them that flexibility if they needed that. And so, yeah, so there it
Councilmember
is.
Lund.
Thank you, Your Honor. Yeah, I mean, I don't know. I had just had a couple questions. I do think 5,000 seems a little low. I don't think 30,000 seems reasonable. I was looking in the 6-7 range, but the reason I take that approach is because, a decade ago it was $5,000 for that type of thing governmentally, and so that's. With inflation and so forth, it seems like you don't get as much with the 5,000, but I think that's being a little nitpicky, 5 to 6 or whatever, so I'm not going to push it too hard. But I do have a question about the language. It says contracts of $25,000. What about contingencies or anything that would make that go over 25? How does that work? Was that a separate approval, or does that all of a sudden... Because contracts versus purchase, right? So that's where I'm wondering. If it's a purchase, we need to buy a ATV or something, it's, that's no big deal. But if it's a contract, it may actually creep up 10% or whatever. And so I'm just curious how that's addressed, if you know.
Councilmember Lund, all change orders to contracts are still required to come before the city council.
Council, I'm going to suggest that we approve this tonight. Reasons why? It's not broken. So that's not, in my opinion, this system has worked very well for the city of Hastings. It's not a system that is broken. And I think we ought to approve it. It's a system that we've had in place for many, many years. It's worked well. We do not have any fiscal issues due to this policy, and perhaps that's probably one of the reasons why. And I would urge us to adopt it as is. Councilmember Balsanic?
I'll move to approve.
Council Balsanic makes a motion to approve the adopt city purchasing policy, seconded by Councilmember Lund. That motion is before the body. Any further discussion? Seeing none, all those in favor of that motion say aye. Aye. Those opposed, nay.
Nay.
The motion prevails. Okay. We have next, as I look out across the crowd, comments from the audience. Do we have any comments from the audience this evening? Any comments from the audience? Okay. Seeing none, council announcements. Do we have announcements? Councilmember Balsanic.
Well, Your Honor, there's two things that I'd like to see us do something about. One, I think, is of immediate concern, and that is the parking situation on Ashland between 6th Street and 10th Street. Parking is allowed on both sides of that street right now, but for our football games and events down at the stadium, it is extremely tight. And so what I'd like to see is, at least for the events, that we post parking only on the one side of the street. The football team especially is getting very popular with its winning record, and there was a huge crowd at the game. Parking, on the street, there's plenty of parking on the streets all around, but Ashland, having been reconstructed, is a little narrower. We did that because we wanted the sidewalk to go along it, but you really can't even get one car through there if there is parking on both sides.
Okay.
So if we could get the police or Public Works to do something on that, I'd really appreciate it.
Okay.
The other thing is, and this has become kind of like a tennis match with Melanie and me, that tobacco ordinance. We had touched on it lightly about sending the ordinance to a committee to take a look at the age requirements for purchase of tobacco items. And so I would like to see that sent to a committee, an appropriate committee. I don't think we need a vote on that, or do we? But if we could get the ball rolling on that. I'm a smoker. I have been on and off for 40, 50 some years, 50 years, I suppose. I started when I was 17 years old, and it was very easy to purchase tobacco products at that time. And we know statistically that if a child does not start smoking by age 18, they will not smoke. So if we could think about increasing the minimum age requirement for purchase, I think we would be doing well. There are a number of cities in the metro area and really across the state that are falling into line on this. I know Councilmember Vaughn had said when we brought this up initially that this is perhaps something that the state should address, but I think by creating these ordinances, even though they may not be enforceable on our part, do send a message to the legislature to do something. So at the very least, let's send it to a council committee. Let's see what the council committee comes up with, and then we can take a vote accordingly.
Okay. I'm just kind of look at a committee that might be appropriate. Probably we could either send it to administrative committee or to public safety committee. Administrative committee? I think. Yeah. Why don't we send it to the administrative committee? Chair Brox and Councilmember London Fulch. Okay, we'll send that to your committee.
I will, Councilmember Balsanic, I will warn you, I have looked into this and I have done some research on it before we when we were discussing it previously. I don't know if there's a lot of public support for it. I don't know if there is a good amount of data to back up such a change, but obviously we're willing to bring it to committee and have that discussion. I just want to let you know what I've found so far.
Your Honor.
Councilmember Lund?
Thank you. And regarding the parking, so I just, I don't disagree with you. That whole area over there makes me concerned, especially I'm gonna walk with my boys, you know, and I'm going down the game. It's super dark and cars everywhere and whatever. And but we did redirect the plans. You, Councilmember Liefeld, and myself, and me, I should say. We redirected the plans to make that wider because of parking down there. So it was supposed to be narrower, and then we had them increase it so we could have parking on both sides again and still have that sidewalk. We pushed for that sidewalk, right? I think that's a huge safety feature that we have built in there that wasn't originally in there, and they made it work, and I'm glad. So I'm not saying you're wrong. I'm just saying that we did, you know, maybe spend extra money to make it wider for the purpose of parking, and parking is challenging to find as it is, so perhaps there's another remedy other than just not parking on both sides of the street that we could do with, I don't know what the solution is. I'm just saying maybe we could look at the problem and come up with a solution instead of that being the solution on the table at this point, because I'm happy to hear it, because it is a cluster down there. Nope. That's probably a wrong word for tonight.
I don't think we want to talk about clusters.
You said cluster too many times.
Have staff look at that issue and come back with proposals.
Your Honor, and again, I'm only talking about during events. Yeah. This is not permanent, no parking along that street.
Councilmember Fulch?
I concur. I dropped off my son for the game, and I dropped him off in our Savior's parking lot, and then so that was like 8th Street, and so I was going back towards 61, and I went to turn on, I'm not good with the streets through there, I get, but, so maybe it was Ashland, so it was like one block towards our Savior's, towards Highway 61, and I literally I was gonna take a left turn, and I was like, oh my God, how are these cars on this street? I mean, I have an SUV and it's only a midsize. I could not fit my midsize SUV down the street. It was that tight. I was, I felt bad for anybody parked on either side of the street because I don't even know how they're gonna get their cars out of there. It was incredible. It was really startling. If I hadn't seen it with my own 2 eyes, I wouldn't have believed it. It was a good day to be on a moped. We'll just put it that way. So.
Okay. All right, is there any other announcements? Any other announcements? Seeing none, I have a few announcements. Council, Tuesday, September 18th, tomorrow, at 6 p.m., the Parks and Recreation Commission will be meeting. And at 7 p.m. later, an hour later, the Heritage Preservation Commission will be meeting. That's tomorrow, September 18th. Parks and Rec at 6, 7 p.m., Heritage Preservation Commission meeting. Thursday, September 20th, this Thursday at 7 p.m., the HEDRA meeting has been rescheduled. And I don't know when that's been rescheduled for. It's for that day? So that is the rescheduled date. So on Thursday, September 20th, 7 p.m., HEDRA will be meeting.
7 p.m.?
At 7 p.m.
6:30.
Okay? Okay, well, I need a motion to amend. No, I'm just teasing. 6:30. 6:30. On Monday, September 24th, at 7 p.m., the Planning Commission will be meeting. A week from tonight, September 24th, 7 p.m., Planning Commission. And on Monday, October 1st, at 7 p.m., is the next City Council meeting. Hard to believe October is coming up right around the corner. Community events that are coming up, an important one that's coming up. There's a 2-part community training coming up starting this Thursday, September 20th, and then next Thursday, continuing to on that next Thursday, September 27th, at the Hastings High School. Using timeless research resources like Diversity Wheel and Dimensions of Culture, we will be exploring what makes each of us unique and embrace the community around us. This training will be led by the YMCA Equity Innovation Center. We are asking for participants to sign up on our website. So if you're interested in this subject matter, and it's very important, please go to our website. You can also go there and go to hastingsmin.gov, search for equity, and get more information and to sign up. We also want to recognize, many of you know from late last week, Councilmember Brox and I and Julie and Melanie were there to see Lee Stoffel receive the Leaders in Local Government Award for her work in marketing and communications for the city of Hastings. Well earned, and that was sponsored by the St. Paul Chamber of Commerce that had done that. So it was a metro area type of contest, and so we won this from the whole metropolitan area. So a shout out to Lee, and if you get a chance, please congratulate her. And today is a very special day because Councilmember Brock is having another 30th birthday, and we're so pleased to celebrate that with you with a council meeting. It's not my 40th yet. It's not your 40th. Yeah, that's good. That's great. Yet, yeah. I can't remember my 30th birthday, so congratulations there. So, but happy birthday, Councilmember Brock. Council, there's no further issue before us. A motion to adjourn is in order. Councilmember Liefeld makes that motion to adjourn, seconded by Councilmember Brock. That's a non-debatable motion. All those in favor of that motion say aye. Aye. Those opposed, nay. The motion prevails, and we are adjourned. Thank you.